right, so my goal here today, when this second screen comes up, is we're going to just go through a pretty quick review of the first half of family law and what's going to be tested in the midterm. And we're just going to go through each particular section up to section 8, just to give everybody an overview. Most of the questions that I've gotten from people have just been like, wow. So hopefully this was taken from wow to, oh, okay, this is all right. These are the rules that we're looking at, and this is how all the doctrine kind of fits together. And the skills matter. What I've done is the syllabus, we've taken the syllabus, and we're going to start looking at each piece of the syllabus independently so we can understand what rules we're going to be tested on in a couple of days. This is going to be one of 3 in-class skills, 3 in-class reviews. The professor's going to do one on Sunday, and then Wednesday before the exam, we're going to be doing another one that evening after evidence. So you'll have 3 times, we'll be having 3 reviews, and we'll probably do a couple of just random questions and things of that nature, so just to get you guys in the mode of understanding how family law questions are for multiple choice. So, since this is just going to hell, I'm going to be talking off of this one, but you guys, if you guys can pull it up on Twin, does everybody over there have it? Yeah. All right. So, if you're going to, this is the Family Law 2018 review, and if you look at the first part, it asks just what is a family. So, in module 1 on the syllabus, what is a family? So we have 3 cases that this section started out with. It started off with U.S. Department of Agriculture v. Moreno, Village of Beltor, and Moore versus City of Chicago. So one of the biggest questions I've been getting from the class is, how does all this fit together? So let's start with the first case. So U.S. Department of Agriculture v. Moreno. That case was, and Ruth Ann and LADP calls it the hippie food stamp case, right? Hippie food stamp case. And in that case, the issue was the federal government defined household in a certain way, right? Unrelated people who lived in a household, and we weren't giving them food stamps. And here, the courts looked at it under a rational-based review. So you'll see on the review sheet the issue, the constitutional provision, level of scrutiny, and the holding. The court said, well, the bare desire to harm an unpopular group is unconstitutional, and it defined household and family broadly. So our first understanding of how the court's looking at family is broad. You can have unrelated people, you can have people, but it's a broad understanding of what family is. In the Village of Belter and Boris, there's a separate issue that happened. We see a narrowing of the rule because here we have college students, right? That's the case with college students living together, and there was a state statute that kind of restricted unrelated people living together. But that's different than if we have related people in a family living together versus college students rooming together for college. So the court, in this sense, narrowed the rule a little bit and gave us some factors to look at. If all these people are related by blood, that is something we'll be looking to look at differently versus groups that are vulnerable and bear desire to harm. So we have a little bit of Moreno sprinkled in there, but these are the factors the court wants to look at to determine, are we going to protect this group who are living together more, or are we going to protect them less? College students less, families who are related more. And then the court, in the last case, Moore versus Cleveland, you had the grandmother who was living with her grandchildren, and the city had a statute that kind of made that illegal, and the court said, well, no. All related, if you have a family, everyone's related there, we're going to protect because they created a fundamental right to live as a family unit. So if you look at this first section, we have a spectrum now. If we have a group of people who are all related living in a household unit, we're talking fundamental right? The court's going to look at that differently than college students rooming together who are unrelated. And this spectrum is what this first section is talking about. Are we all right? And I know I said a lot of stuff, but did I confuse anybody? I thought I confused you. You were looking confused. Am I confused? All right. All right. So this spectrum is from the first section that we're looking at. Is it pretty clear that if we're all related, that's one thing, but if we're just all college students or law students who are not related, that's a different thing. And that's what the first section is kind of explaining to us. Any questions?
Yeah, you were talking about the standard of review, rational basis or strict, I think. But question, in your review sheet, you put the what constitutional part is touching, like the Fifth Amendment or the 14th Amendment. And when we read the cases, we didn't talk about it.
Oh,
So my question is, do we have to know that?
no, that is unusual fluff. I just put it in just to make sure.
So we don't have to
understand.
know
No.
that. Good.
You don't have to know the constitutional provision. I just wanted to make sure I put it there so you guys would be able to follow me. Also, at the end of this, it just tells you about the spectrum. I'm going to be moving on because time is limited. So now in part two, we're talking about, okay, so now we kind of decide how the court's going to look at family. And again, you want to look at those factors because if you get a multiple choice question, you understand the spectrum. Part two, parental rights. Now we're starting to talk about parental rights and now how the court are going to look at parental rights. And we have the same type of situation going on. We have broad, then narrow. We have a very broad rule, and then over time the court has to narrow it because, again, this is what happens when you establish a fundamental right and the states want to restrict it in some way. So here in Myers v. Nebraska, the state restricted students from learning any other language until they completed the 8th grade. But the court said no. We have strict scrutiny and established a fundamental right. Parents have the fundamental right to the upbringing of their children. Very broad rule. Right? And then 2 years later, in Pierce v. Society of Sisters, they established another fundamental right. Parents have the fundamental right to decide the mode in which their children are educated. Again, a very broad role. Now, I didn't put the last two cases because I wanted you guys to look through them and see how the court either narrows or broadens this rule. But understand that in some cases, the court does narrow these rules because if these were just the rules where you can upbring your children in any way possible or you can educate your children in any way possible, that's too broad. We know there's certain restrictions which children have to learn. Parents can't do certain things and two children and children for instance, children have to be educated in a certain way even if you homeschool them. So there are reasonable restrictions, but how the court gets there, that's what this module is explaining. First, very broad, and then we're narrowing in these last two cases. The same kind of theme from the first section. We all on the same page? So now moving from section 3. Section 1, broad to narrow. Section 2, broad to narrow. Now we're going to section 3, before getting married. And now, instead of outlining the cases I did before, because before we were talking about more of the background material, understanding how things were developing, now we're talking about, well, first, premarital contracts. And in Simone, it was a simple proposition. These are contracts. And if they are contracts, then the court's going to look at them as contracts. And that's what this case stood for. Prenuptial agreements are contracts and should be evaluated on the same criteria. Absent fraud, misrepresentation, duress, spouses should be bound by the terms of their agreements. I think a very simple understanding, but now if you do have a prenuptial agreement, these are contracts, and you're kind of looking at contract law. And we all understand that sometimes courts thought of marital couples or couples differently when you're talking about prenuptial agreements, but the baseline is they're contracts. Then, in the marriage of Schenck, we then have kind of an evaluation of how we evaluate premarital contracts. And the court gave us three modes in which to look at them. So 3 independent bases for finding a prenuptial agreement, premarital agreement, unenforceable. Voluntariness, unconscionability, and financial disclosure. And obviously you have things like fraud and duress that could also appear. And you'd want to also look at those when you're talking about a premarital contract. Again, you're looking at prenuptial agreements or contracts in this way. Have I confused you guys enough, or we're good? I know I'm talking fast, and everybody's got that glossy-eyed look on right now, but good. Question?
I'm not confused. I'm just concerned about how this could be tested with multiple choice questions, if that makes sense.
Well, if I
Are
ask
there
you, for
practice
instance,
questions, or?
Well, there will be practice questions. But for instance, here, I can ask you easily if a premarital agreement is enforceable and give you one of these 3 criteria, or have a question that has 4 different ways to find it unenforceable, and one of these would be missing. Like for it, it'd be voluntariness. The person just wasn't voluntary. Now we're halfway through, and I have 15 minutes left, so I'm good on time. So does anybody have any questions? Because I know I'm talking fast, but I'm just trying to get through all this material, just to give you guys a grounding on what this means and how to move through. So is everybody good right now? All right, moving on to part 4. Part 4 is about getting married. And again, let's go back to the same thing. We establish the right, which is the broad rule, and then we narrow it over time. So the establishment of the rule was in Loving v. Virginia. Marriage is a fundamental right. Very broad. Hey, we can all get married. But we know, even though that rule seems broad, it wasn't really as broad. And then you still have a narrowing of that rule. Now, Zablocki explains how that rule is narrowed a little bit over time. For instance, does the exercise, in other words, Zablocki is the state can regulate marriage in a certain way, but here's the test to determine whether they've gone too far or not. If it's direct and substantial interference into whether people can get married or not, you're applying strict scrutiny, but if it's not, then you're applying a rational basis test. So think about this. When you have states who require a license to get married, and if you don't get the license, then you can't get married, you're looking at Zablocki to maybe make an analysis to determine whether that requirement for a marriage license to actually be married is a direct and substantial interference. But states like New York, where even though you need a marriage license, but if you don't have it, you can still get married, that may not fall under this particular test. Because in New York, even if you don't get a marriage license, but you get solemnized, your marriage is still good. But some other state can say, well, hey, if you don't got a marriage license, your marriage is not good. So this is where you employ Zablocki to see whether it's a direct or substantial interference in getting married, a narrowing of the rule. And the last place is a more narrowing of the rule is turn and be safely, and that's the rule whether the marriage restrictions are reasonably related to penal interest. That was the person in jail who wanted to get married, and that actually has the exception too, where if you're serving life imprisonment, then they don't have to allow you to get married. So broad rule, and we have 2 cases that narrow it over time. Do we have any questions?
I guess with the Zabrowski case, could you think about it back to LEDP, like the gun ban? Like if it's a partial ban, then you can give it rational, and if it's a complete ban, you'd go to strict. Are those like terms kind of similar?
Yeah, it is kind of similar, but again, I would just use the language direct and substantial interference.
Got it.
And you exactly the same thing. So now we're moving to section 5 of the syllabus, and that's talking about restrictions on marriage. And again, the first case was about the marriage license, just what I was talking about, and the fact that even if you didn't get a marriage license, your marriage was still good because it wasn't a substantive defect. So again, marriage license, in this particular case, even if there was no marriage license, the court would hold that the marriage was valid. But I put here, don't forget Zablocki, because if it was the opposite way around, then you'd have a Zablocki issue, because it would be a direct substantial interference in getting married. In Re State of Duval, I just kind of left that so you guys can read something, because I was like, I got to give you guys something to do. So read it.
Can we go back to what that means? Don't forget Zablocki.
Yeah, because let's say, for instance, if without a license your marriage was no good, then you could then apply Zablocki and say, well, this is a direct and substantial interference for me getting married, and then you would apply strict scrutiny because it's a fundamental right. Did I answer your question?
Well, I kind of thought once you got through those first 3 cases, everything with parenting was strict scrutiny. Does it keep switching back and forth with the cases?
Well, Zablocki says if it's direct and substantial interference, if it's yes, then you apply strict scrutiny. But if it's no, if it's not direct and substantial interference, like the licensure in New York, it's not because you don't really need it,
Right.
then you would just apply rational basis. So that's when you would use that. So what I did do, since I was too lazy to actually go into the ball, I said, well, let me give you guys the general rules in New York. General rules is New York requires a 24-hour waiting period, 60-day expiration. It actually happened to us, where my wife was like, oh, it's been more than 60 days. And I was like, well, it is what it is, you know what I'm saying? 60 days, 60 days, you know? But we're still married, so yeah, there's no way to, you know. So solemnization, you have the contractual wedding, 2 witnesses in judicial acknowledgement. You have the ceremony, take each other as husband and wife, only one witness needed, and marriage by authorized person. So this is just the New York rules. I wonder if everybody be familiar with that. Part 6, substantive restrictions on marriage. Now again, here I didn't go into the cases because I thought it was interesting to go into the void and voidable piece of the doctrine here. So marriages are void if you're trying to marry more than one person, and if it's incestuous. And here's what incestuous means. So, and we all understand what void means, right? That's like the marriage never happened. Here are voidable marriages. Now remember, voidable marriages aren't generally allowed by both parties. It's actually, for instance, in cases of fraud, it's the party who's defrauded. In cases of age, it's the party who's underage that can actually ask for the marriage to be voided. And again, you have to go to the court and request it. So here are the 5 ways that marriages can be voidable. Consent, 2 capacities, another consent, and an incurable mental ill, and curably mental ill for 5 years or more. I might be thinking about using that one. And then we have, then I went into, this is New York statute about age, and it's kind of crazy. You can marry a 14-year-old in a state. That's kind of insane, right? Is it me? Did anybody read that? It's like, that's insane. You marry a 14-year-old. No? Am I the only one? I don't know. Like, we had to change that. Like, no, why did they change that? Even though I saw they're going to change it, but that's not like crazy. 14 to 15 with parental consent, 16 to 17, and 18, obviously you don't need anything. Here are the elements for fraud. So this is what you have if you're asking for the court to void your marriage based on fraud. First element, the defendant knowingly defrauded the plaintiff. The fraud must be material, and that just means the plaintiff wouldn't have married the person if they knew the truth. Now, there's some cases about, the one person couldn't have children, and you're like, oh, if I'd have known that, I wouldn't have married you, but you have to do that evaluation. Plaintiff had to discover the truth in a reasonable amount of time. A reasonable person would have been deceived by the deception, and plaintiff must disavow and cease cohabitation upon discovery. So these are 5 easy elements to if a question concerning fraud came up, and the rest is not going to be on.
There won't be a question concerning
Yes.
fraud. I mean, I mentioned it because I think it is sort of an important doctrine which we would have gone into if we had more time. Totally fascinating, crazy cases. But yes, since we didn't actually do a case on it, it will not be on the exam.
So now, any questions? I feel like I'm going to faint up here. One agreement so heavy, right? Yeah, no. All right, so we had a question over here, now coming to you.
Is the New York State law stuff going to be on the exam?
The New York State law stuff isn't going to be in the stand, but I'm going to give them as examples of age and void and voidable. But the concepts of being void and voidable are going to be on.
Right. Knowing that the incest and the bigamy, that those are void marriages. That'll be on there, but not the specific parts of the New York statute.
Now, back to Marvin v. Martin. And it's funny because I keep calling it Martin v. Martin because I grew up on Martin, the TV show, and Martin v. Martin, but it's Marvin, so I got to make sure Marvin v. Martin. So Marvin just stands for the takeaway that courts should enforce express contracts between non-marital partners, except to the extent the contract is supposed to be founded on considerations of meritorious sexual services. So contracts of prostitution are illegal, but in the absence of any express contracts, courts should inquire into the conduct of the party to determine whether or not the conduct demonstrates an implied contract. So this is I call it the rich man can't escape the young wife clause, because again, that's what they used to do. It's like, all right, I'm divorcing her. Well, I'm not divorcing, I'm leaving her, we're not married, but this allowed them to have some type of recourse in the court to say, no, we had an agreement. And I think in this case, it was marital property he used to build his business, and then he was trying to just bounce, and they were like, no, you owe this person something, you had an implied contract. implied contract. Any questions? We're at the end. I feel like, I like that separation anxiety. I don't want you guys to go.
Yeah. All right. Well, hopefully this has sort of got, been a good base for you guys to dive into the rest of your review, and any questions kind of percolate as you look at the stuff. Email me and, bring to the review, and we'll go through all of them.
Question?
When will a practice exam be ready?
Well, we're working through some questions now, but you should have one hopefully by the beginning of next week, and I'll probably be throwing a couple of questions just up on swing.
Right.
But
And
it's
I'll
working.
distribute at least a few before the practice session so that we can talk about them on the review session on Sunday.
Hold on, before we leave, we got one more section, sorry. Common law. All right, so common law marriages. Now, again, the cases are up here, but we all know that there are 4 elements for common law marriage. So just know these 4 elements because these will be tested. The 4 elements are holding ourselves as husband and wife, present agreement to get married, capacity to enter into the marital contract, again, incest, bigamy, things of that nature, wouldn't allow you to get married, and cohabitation. Remember, sometimes 3 days is enough, and the big part about cohabitation is spouse-like intimacy, and you don't have to cohabit, and you can occur in states that don't recognize common law marriages. So understand those 4 principles. Those are the 4 elements that you need to know. So we've gone over the first 8 pieces, and we'll dive into it in more detail, each particular section. But this is just a nice little grounding so everyone understands what you need to know for the midterm and how it all is laid out. So with that, do we have any questions before everybody jumps up and run out the room?
Can you just email out when the review sessions will be?
Sure, but one is Sunday. Professor's going to give us a
Yeah,
time.
I expect it at
and
3
Wednesday
p.m. Once
before
the room's
exam.
officially confirmed, I will email that out.
Okay,